You know, one of the main questions that I'm asked by potential clients is whether or not they're facing a jail sentence at the conclusion of their case. Now, you must understand that every single crime that's on the books is potentially punishable by jail. But there are certain crimes where jail typically is not an option. So, for example, a misdemeanor or a simple possession of drug offense, especially if you're a first offender. But the question of whether or not someone is looking at a potential jail sentence depends upon numerous factors. The first, of course, is what's the crime? Is it a violent crime? Has someone been injured? Does the crime carry a minimum mandatory jail sentence? What's the loss to the victim? What's the criminal record of the individual who's charged? And most importantly, who's the judge on your case? Because ultimately, at the end of the day, at least in federal court, the sentence is up to the judge. While in state court, typically, a sentence can be negotiated between the prosecution and the defense, and the judge can either accept it or reject it. So if you're concerned and you've been charged with a crime about whether or not you're looking at a potential jail sentence, you should consult with an experienced attorney like myself. Because once all of the facts are discovered, and once all of the information is reviewed, and your personal history is taken into account, only then can a determination be made of whether a jail sentence is or is not an option. Have any questions that haven't been answered? Feel free to give me a call. The consultation is free.